Republic Act Number 8293. An act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing for its powers and functions, and for other purposes. What is intellectual property? In the Intellectual Property Office of Section 2, Declaration of State Policy, the state recognizes that an effective intellectual and industrial property system is vital for the development of domestic and creative activity, facilitates transfer of technology, attracts foreign investments, and ensures market access for our products. It shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such periods as provided in this Act. The use of intellectual property bears a social functions. To this end, the state shall promote the diffusion of knowledge and information for the promotion of national development and progress and the common good. It is also the policy of the state to streamline administrative procedures of registering patents, trademarks, and copyright, to liberalize the registration on the transfer of technology, and to enhance the enforcement of intellectual property rights in the Philippines. The current issues of intellectual property in the Philippines. Number 1 is patent. Patent is an intellectual property right granted by the government of a nation to an inventor that gives him or her the exclusive right to the invention for up to 20 years. In exchange for disclosing the details of the new technology to society for its ultimate benefit.
Copyright issues in the Philippines. Intellectual Property Code of the Philippines, also known as Republic Act 8293. It is an act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing its power and functions. And for other purposes, also copyright is a collection of all rights enjoyed by the owner of an artistic or literary works. Unauthorized download of movies, apps considered as copyright infringement. Unauthorized download of music instead of buying the music from eligible source or app is a copyright infringement.
3. Trademark.
Trademark protects other types of intellectual property. Trademark is a tool that prevents a company from adopting a name, tagline, or a product's configuration that is confusingly similar to that used by competitor. Trademark help consumer identify the source of what they're buying or using. Patent protects inventions and discoveries, ideas, processes, methods, concept, machines, and devices, things like that. Patent law protects an idea, while copyright law protects the expression of that idea, the exact words of form chosen to convey the idea. Copyright protection is governed by federal law and has been a part of this country since its founding.
And number 4, trade secrets.
One of the intellectual property protected by law is trade secrets, which enable people earn recognition or financial benefits from the inventor create. Companies of every use trade secret to get a competitive edge and protect their intellectual assets, which is the industrial processes, strategic plans, customers' data, and so on. Trade secrets are not limited in time, have no registration cost, and are effective immediately, but unlike patents, they may be used by others if discovered and are more difficult to enforce.